Just hit the go live button, and we want to make sure that this is simulcasting, multi-streaming, broadcasting across a number of different locations. Let's make sure that we're ready to go. Looks like we're live on Facebook, we're live on Periscope, we're live on YouTube, which is great news. And hello, everybody. Welcome back to another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here in Scottsdale, Arizona. I've been practicing law for about 7 years now, coming just on the 7th year. And over the course of my time practicing criminal defense exclusively, my team and I, over the years, we've seen a lot of misconduct, a lot of malfeasance, prosecutorial problems, judicial problems, bad police officers, bad politicians, a lot of people involved in the system that are contributing to the downfall of it as we're sort of seeing unfold around our country during these times. And so we started this program called Watching the Watchers because we want to make sure that we're holding the people who are supposed to be enforcing justice and enforcing the laws, we want to hold them accountable. Unfortunately, we've seen way too many times where police, they'll get in trouble and they'll go through a separate system of justice, something a little bit different than you or I would go through if we were charged with the same offense. And so what we do on this show is just shine some transparency down on those involved in the justice system, in particular, the police, the prosecutors, the judges, and the politicians. And so today what we're going to do is continue on with a lot of the stories that we've been following for some time. In particular, we're talking about the McCloskeys. We've got Mark and Patricia McCloskey. They were indicted yesterday on additional charges. We've been covering that story since it broke. We've got some updates. We're going to share those with you. We've also got some more information on what's going on with Netflix and Cuties. Netflix was indicted. The CEO and the co-CEO were both indicted out of a county in Texas. So we're going to talk to you about that as well. And then finally, we're going to wrap up with the news of the day. Derek Chauvin, the officer who was responsible for putting his knee on George Floyd's neck, resulting in his death. He's been charged with multiple counts of murder. He was released from custody today. He was the last officer to actually be released, and so he got bonded out. We're going to tell you what happened there, what that looks like, and what is next for those 4 officers who are all going through the criminal justice system as we speak. So a reminder, this is live, so please feel free to hop in the chat and have a conversation with your fellow watchers here, and subscribe. If you're joining us and you're not a regular subscriber, a regular part of the show, hit that subscribe button because we are here every weekday at 4 p.m. Arizona time, 7 p.m. Eastern time to talk all the legal news. We've also got a little bit of Supreme Court gossip we'll get to at the end of the show, but not too much there. So let's dive into it. We're starting off with the McCloskeys. So we learned yesterday that a grand jury indicted both Mark and Patricia McCloskey on Tuesday with charges of exhibiting guns at protesters, which we all kind of thought was coming. And then they added a charge of tampering with evidence. You remember these two? This is Mark and Patricia McCloskey. This case happened several months ago out of St. Louis, and we saw these protesters were coming through their private property. This couple lives in a mansion, huge, nice, beautiful piece of property. There were protesters that were walking down the street, and they were allegedly peaceful protesters, but we've covered it on this show. They actually broke down the gate. We have covered on this channel videos of the gates being spliced open, broken down, and so they were walking through the McCloskeys neighborhood. They came out. They had these guns. We're going to talk a little bit more about this silver gun, but they had these 2 guns, and they came out and they were sort of protecting their property. I mean, in their mind, these people just broke into their private sort of HOA community, and they were threatening their livelihood, threatening their property. Remember, around this time, there was a lot of chaos going on all around the country. They were literally, injuring people and burning down buildings. And so when we did our analysis, we thought, pretty fair deal. They were on their property. They were defending their property. And from our original interpretation of the statutes, I didn't see how they were going to actually get charged as this moved forward, unless it was going to be a political prosecution, which it turned out to be, or in my opinion, it is turning out to be. So we're going to continue, following the story. Their attorney, Joe Schwartz, said yesterday that he wasn't surprised by the grand jury because they didn't have any facts. This was his statement. He said, once all the facts are out, it will be clear the McCloskeys committed no crime whatsoever. Frankly, because the grand jury is not an adversarial process and defense counsel are not allowed in there, I have no idea what was stated to the grand jury and what law was given to the grand jury. So that is from the McCloskeys' attorneys. And that's technically true. I mean, that defense attorney is right. They are private proceedings. But at least in Arizona, there are things you can do to get sort of involved, sort of nudge your way into those grand jury proceedings by filing what's called a Trebus letter here, and you submit that, and you can almost make your claim during the grand jury proceeding. So I don't know if that happened in this case. Certainly, this defense attorney is going to be able to review the grand jury transcripts, and he'll learn more about what was actually occurring during that indictment proceeding. But as it stands today, we don't have a copy of the indictment. We have not seen any of that material, but we do know that they were charged with the one count or multiple counts of tampering with evidence, which was a little bit curious. And so we're going to talk about that as well. Watkins, Attorney Al Watkins said the gun was inoperable, this silver gun that Patricia had. It was originally inoperable, but then Kim Gardner, who was the head prosecutor out of this county, well, we have the screenshot of it where they actually went in and adjusted the firing pin of the weapon. So they took this weapon from Patricia McCloskey. They got a warrant. They went into the McCloskeys' home. They took these weapons. They tried to dry fire that silver pistol. Were not able to do that because they found that the firing pin had been removed. So they take an inoperable weapon. They take it apart, or they try to dry fire it, doesn't work. Reassemble the weapon. Find out that it does work, and then they log it into evidence. So that's a little bit weird. And so we flagged that when it came through the first time around. And we have it here again. Mark McCloskey said this was his position as he was standing on his property, as these people were breaking into his property, or into his HOA sort of community space. He said, they broke down our gate. They trespassed on our property. Not a single one of those people are now charged with anything. Mark said, we're charged with felonies that could cost us 4 years of our lives and our law license. And so, I mean, do I think that's going to happen? No. Do I think these guys are going to go to prison for 4 years? No. I even think that there was a diversion offer on the table from the prosecutor. In other words, the prosecutor was giving them an easy out, saying, if you just agree to forfeit your weapons, if you agree to let this all go, take some classes, then we're going to dismiss the charges against you. And they said, no, we're not going to take that deal. Thanks, but no thanks. And this has been sort of being kicked around for a while. We have a statement from Mark McCloskey here. And before we play that, I wanted to also refresh your memory that there were, I think, 9 people who were originally charged with crimes for breaking and entering. It's called a crime called criminal trespassing or disorderly conduct. There's a number of different charges that those protesters could have been charged with. And I think they were, in fact, charged. We covered that here. I think 9 of them were charged. Well, those charges were later dismissed. So they're no longer being prosecuted. As of my most recent knowledge, I think all of those cases have been dismissed and disposed of. So now it's only the McCloskeys who are being charged. And they've got a lot of resources. They've got a lot of money. They've got a team of attorneys who are working for them. And they just made an appearance in court. And we have a statement from Mark McCloskey where he's explaining what happened. Let's take a listen.
What you're witnessing here in this case is just an opportunity for the government, the leftist, Democrat government of the city of St. Louis to persecute us for doing no more than exercising our Second Amendment rights. Every single human being who was in front of my house was a criminal trespasser. They broke down our gate. They trespassed on our property. Not a single one of those people is now charged with anything.
Last week.
Yeah, and it is, it is unfortunate this case has become so political. We talked a lot about this when the story was first breaking. The idea that these movements, BLM and Antifa and all of these other groups, they want to come out and defund the police, and then they expect homeowners to not defend themselves when the police don't show up. I mean, you really can't have it both ways. If you want to defund the police and say you're on your own, or put in some sort of community civilian something or other, which I still don't even know what that looks like, what's going to happen when you have a situation where the protesters are actually breaking into your property and the police don't show up because they've been defunded, or just because they've been told to stand down? This is part of more politics. And I think if those movements are successful, if we do see less police on the streets, if we see less ability for them to respond, then we're going to have more McCloskeys. That is the only logical conclusion here. People are not just going to say, oh, you're peacefully protesting, you're breaking through our gated community, come on in. why don't you just come on into my house? What does any of this look good for you? Take what you want and enjoy it. That's not going to happen. People are going to be defending themselves. They're going to be using firearms and using weapons to protect themselves. It's why it's in our Constitution, because it is that important. So I don't know what these prosecutors are hoping to sort of obtain here, other than just a win, sort of a black eye in the face of the Second Amendment gun rights individuals in the country. I don't think that if this is a successful prosecution, this is going to be good precedent, but I just can't imagine it really goes anywhere just because of the facts. Now, that being said, there is a little bit of a twist in the charges. Where did this evidence tampering charge come into play? I understand the pointing weapons at other people, and I understand those charges. I totally disagree with them, but I understand them. But we don't know yet where this other tampering of evidence charge comes into play. What is that all about? And if you remember, back when this story first broke, we had this screenshot from the crime lab where they were actually admitting and making part of the police record that they did disassemble and reassemble this weapon that Patricia McCloskey had. And so this is from the record. This was from an article from ksdk.com. Gardner staffer ordered crime lab to reassemble Patricia McCloskey's gun. Said this is literally from the police report. The firearm could not be test fired as submitted at the request of ACA Chris Hinckley, which is the probably the county attorney. The firearm was field stripped and found to have been assembled incorrectly. Firing pin spring was placed in front of the firing pin, which was backwards, and will not fire in this condition. The firearm was reassembled properly, test fired, and functioned as designed. No additional defects were observed. Submission is digital media card containing 7 photographs documenting the disassembly and the reassembly, and then they submitted it all into evidence. And that's interesting, right? I mean, sounds to me like they were the ones manipulating the evidence. Now, the alternative argument would be that the McCloskeys, they had a weapon that was fireable, and because they started to have concerns about being prosecuted, they went and manipulated that evidence. They switched the firing pin. So they had some sort of firearms person, or they themselves, maybe they know how to do it. They disassembled the gun, swapped out that firing pin, reversed its position, reassembled it, so that when the police did come and secure their firearms, that they could say that it wasn't even a functioning firearm. How can you be, in other words, how can you be charged with pointing a firearm at somebody if the firearm doesn't work? It'd be like pointing, your cell phone at somebody. It's not going to function. It's just a piece of metal at that point in time. It's not a functional weapon. So if that's the case, and the police found somebody who said, yeah, I went over there and I made some adjustments to the weapons, then I could see how that could be interfering with evidence, or at least an allegation of that. But at that point in time, had they been charged with anything? This is where the timeline is going to become very tricky. Had the McCloskeys at that point in time been charged? Had they been under investigation, prior to the warrant? In other words, is it their property? Could they just go ahead and do whatever they want with their property, right? Because that was not the subject of an investigation. And so we'd have to go back and do a little bit deeper dive into specifically the timeline on how that all unfolded. Because if that stuff was not part of an investigation, or was not claimed by the government, or the government didn't say we want to seize that, or because I know they issued a warrant a couple days later, and then they got the guns a few days after the original incident. So if they made the change to their property, and they were not under the idea that this property was going to become evidence in a future crime, then maybe they can make the argument that it's their property. They're free to do what they want. They can manipulate the firing pins and all that stuff. But when I think back to this story, you can fact check me on this, but I think that the original basis as to why that firing pin was not even installed properly was because this gun was part of a prop that Patricia McCloskey used in a trial. So both of these individuals are attorneys. They know how this all works. And so they had a physical gun that they used in a trial as a prop to show weight, or to maybe it was an actual gun and something, who knows. But what we're talking about here is that they were manipulating the evidence for a purpose, and we're going to see where that manipulation happened. If this is even related to the gun, we don't know. This could be other evidence, deleting things, or something to that effect. So we'll see. We'll continue to follow along on that story. So make sure you subscribe for more McCloskey updates. Before we move on over to the next story, though, they are scheduled for a court proceeding in 7 days. This is the next court proceeding. It's going to be on October 14th at 9:01 in Judge Michael Colonia in his courthouse in the Carnahan Courthouse. And so you see here, back in September, there was a motion for discovery. The McCloskeys have hired an attorney called Joel Schwartz, and they had a hearing yesterday on 10/6, which is where we got those new charges, and they reset a new hearing, which we don't know what that is yet. We tried to pull it up on a different system. So they just are calling it a hearing, don't know specifically what it is or what it's for. May just be an initial appearance, like an arraignment, because they have these new charges. So it may just be the formal announcement of those new charges. They'll say, yep, we're going to, lump those in with the other charges you already charged us with, and we're going to assign the same attorney, and it may just be more of a formal type of court hearing, but nothing real substantive there. But we will continue to follow along on the McCloskeys, because obviously this case is not going away. They were just indicted by a grand jury, so we will be following along for the foreseeable future. All right, the next story I want to talk about, Netflix. Remember we covered this? Netflix was indicted for Cuties. Remember this film we talked about? Yeah, we're talking more about Cuties. This was one of those things that I had to admit on this channel. I didn't watch it. Didn't watch the full movie. I watched about 15 seconds of it on a clip on Twitter, and that was enough for me. Didn't need to see it anymore because of what I saw. It felt dirty. It felt gross. It felt totally inappropriate. Almost just not okay, right? I mean, I watched it for about 10 seconds, 12 seconds, and I just X'd right out of it. And got some criticism for that. There's a lot of people who say, well, you should watch the film, just watch the whole thing. And it's not, I'm not okay with that. I don't need to see it. I already know what I saw. It's enough for me already. And so when we did the analysis, we went through Arizona criminal law, and we were talking about our child pornography laws and our misconduct involving minors and all of our different sex crimes that actually criminalize contact with minors, with underage people. And we were going through the statutes line by line, and we just made a quick comparison and said, yeah, that sounds like exactly what I saw. We were talking about, grinding and talking about nipples and talking about all sorts of just horrendous things in the context of 11-year-old girls. So it was pretty clear to me that this was something that just by the statute could have qualified as, child pornography, or what we're going to talk about here next in the Texas statutes. And so my big thought was, is anybody going to run with this? We covered the story like literally the day that the movie came out. And then shortly thereafter, there were a number of senators and attorney generals and state representatives and people from all over the country who were in agreement. And they said, all right, this is also gross. And so we covered, I think Ted Cruz filed a letter to the Department of Justice. We saw that Senator Mike Lee filed a letter to the Department of Justice. A lot of other people. There were, these letters signed by 10 people, 20 people, all sort of demanding that something be done about what Netflix is promoting here. And we didn't see anything happen as a result of that. And in large part, you can understand why, because Netflix is, it's a behemoth. It's one of the biggest companies in the world. Everybody loves Netflix, and this is art. And, what are they going to do? Are they going to indict and put Netflix in jail? Well, they can't really do that. So what are they going to do? Are they going to go after the other people, the director, the producers, the people who are on set with these young girls? Remember, we just saw what was in the movie, but what happened outside of the movie? What happened when they were coaching these girls on how to act or how to do these dances? Were they showing them? Were they performing on them? Were they making them perform on the adult producers? Who knows, right? We only saw what was in the film, but what happened behind the scenes there? And this is what a lot of people had concerns about. How do these 11-year-old girls know to do those things? Somebody was showing them. Somebody was giving them some education and some guidance on it. And that's really where it became troubling. In addition to what we saw, the whole thing was just disturbing. So we saw a lot of people filing these letters and filing these requests for investigations, and nothing came of it until today. Then we have a town in Texas that actually indicted Netflix with a criminal charge for promoting lewd visual material of a child. This happened in Tyler County, Texas. So a grand jury actually indicted Netflix. You can see here, this is a copy of the indictment, and this was filed, I think it was actually filed earlier. So it was filed on September 23rd, but it was announced today. So we see here the state of Texas. This is taking place in the 1A District Court for Tyler County, the state of Texas. Cause number 13731, no bond. State of Texas versus Netflix. The charge was promotion of lewd visual material depicting children. PC 43262, the indictment in the name and by authority of the state of Texas. The grand jury for Tyler County, Texas, impaneled the jury at the start of January and they took their oaths, and they said that Netflix, the defendant, on or about the 15th of September, did, before this indictment, they did at that point in time knowingly promote visual material which depicts lewd exhibition of the genitals or pubic area of a clothed or partially clothed child who was younger than 18 years of age. And that's basically exactly what I had seen in that clip. It was a clothed child, but it was certainly lewd. And they're under the age of 18 at the time. The visual material was created. It appeals to the prurient interest. I hate that word, prurient interest. You have to get that R in there right after the P. It's difficult. Prurient interest in sex, and has no serious literary, artistic, political, or scientific value by issuing, selling, providing, delivering, distributing, which of course Netflix does, transmitting, publishing, exhibiting, all of those things. The film called Cuties, also known as Mignones, or offering or agreeing to issue, sell, provide, deliver, on and on and on, advertise said film. The promotion of said film was authorized or recklessly tolerated by a high managerial agent of Netflix, namely Wilmot Reed Hastings. Who is that? You remember that name? That is the CEO of Netflix. So they actually name him in the indictment. And then they also name this other fellow, Theodore Anthony Sarandos, who is the co-CEO. He's also the Chief Content Officer for Netflix. So acting on behalf of Netflix within the scope of the agent's office or employment at Netflix, Inc. And finally, against the peace and dignity of the state. That comes from Texas. So that indictment, they just indicted the CEO and the co-CEO of Netflix. It's a pretty big deal. Now, is this going to go anywhere? Probably not. We have a statement from the prosecutor that we're going to get to here in a minute, but both of those guys are worth, I think, a lot of money, and they're going to have an entire force come crashing down on this particular county and on this particular prosecutor. And so we'll see what happens. Now, this is going to be an interesting case to follow because they're sort of naming Netflix and they're charging them with the crime, which is a little bit unusual. Normally you see, individual defendants get charged with a crime. And so we'll continue to follow this along and see where this goes. We tried to find where this case has actually been filed. We tried to find the case minute entries and all of that stuff. And it's such a small county from what I have gathered that we just are not able to find it at this point in time. So we'll see what happens. We do have a statement from the prosecutor, who's the Tyler County Criminal District Attorney. His name is Lucas Babin. And he put out a statement, and he kind of goes through the timeline a little bit further, and he says specifically, on September 23rd, 2020, a Tyler County grand jury indicted Netflix for promotion of lewd visual material stems from promotion of Cuties. The summons was served on the corporation on October 1. Section 43-262 says that it is illegal to knowingly promote visual material that depicts the lewd exhibition of the genitals or pubic area of a clothed, partially clothed. We already read all of that. The offense is a state jail felony. Criminal district attorney said of the indictment, as district attorney, I have to sift through countless cases and make calls every day on how to keep our community safe. In our country, it is not uncommon for me to confront cases with underage victims. After hearing about the movie's Cuties and watching it, I knew there was probable cause to believe it was criminal under section 43.262 of the Texas Penal Code. As did I. Didn't even need to watch the whole film. I got it from about 20 seconds of it. The legislators of the state believe promoting certain lewd material of children has destructive consequences. If such material is distributed on a grand scale, isn't the need to prosecute more, not less? Grand jury in Tyler County found probable cause for this felony, and my job is to uphold the laws of the state and see that justice is done. The prosecutors of Tyler County Criminal District Attorney's Office are subject to rules which limit their ability, and so he's not going to talk about it any further. But I mean, good for this prosecutor, right? We don't see that much on this channel. A big round of applause. You applying the law, applying the rules to the big boys, to the big agencies. We read through it. We saw the film. Everybody who saw the film most everybody. There's some couple weirdos on the internet from some of the, well, I won't even get into that, but there's a lot of people who are really sort of justifying this film and saying, this is just educational, right? We're going to watch it because we care about young girls. We care about how they're overly sexualized. And so we need to watch this film to bring awareness to people. You don't really need to do that, right? You don't need to steal the candy bar to know and experience that stealing the candy bar is wrong. You don't need to sexualize young girls to show that it's wrong. I understand making public commentary about it, and I understand that there's a kind of a separate view of all of this stuff. I just don't particularly agree with it. And quite frankly, my personal opinions aside, the law doesn't agree with it. Okay, I didn't write these statutes. I didn't write the statutes in Arizona or the statutes in Texas. But if you just take the content of the film and match it up with the statutes, it's pretty clear. They meet. All of the elements meet. We're looking for a red here. We got a red here. We're looking for a green here. We got a green here. They match. It fits. And so this prosecutor, as far as I know, is the only prosecutor in the entire country who is able to have the courage, the fortitude to say, yeah, sure, we're going to charge them. Why not? If somebody else was doing this, we would charge them. Why shouldn't we charge Netflix? And that's exactly what we want to see. We want to see that the people who are on uneven power footings, who have more money, who have more resources, who have all the politicians in their book, all of the, all of the weight of this country is sort of intermeshed with a lot of these bigger organizations. And so we want to see that they get held accountable to the same standard that you or I do. When we were looking at the actual law, here's what it says. So, well, we basically already read this, but let me run you through what the statute says. So, lewd visual material depicting a child. This is the Texas statute. It says in this section, promote or sexual conduct have meaning. So we're defining a couple meanings. We've got visual material defined over here in 4326, 4325, have some more definitions. And then what you're going to see here is a statute that says all of these things basically need to happen, right? A person commits an offense if knowingly possesses, accesses, or promotes a visual material that does this. We've already explained it. It depicts the lewd exhibition of genitals or pubic area, appeals to the prurient interest in sex, has no serious literary, artistic, or political or scientific value. And so what the defense is going to argue is that when you read a statute that looks like this, you're going to see this word "and" here. All right? What that means is that in order for this to be a criminal offense, it has to hit all three of these. Okay, it doesn't say or. So if this says or, then this would mean that as long as what Netflix did hit one of these elements, either 1, 2, or 3, then that's enough. But here, because there's an and, it means it has to be all three of these. So it has to depict genitals or pubic area. It has to appeal to the prurient interest in sex. And it has to have no serious literary, artistic, or political or scientific value. So that is the definition. Now, Netflix is going to come back and say, well, listen, as to number 3, we think it's got a ton of artistic value. And that's going to be their defense. And they're going to say, in order for this to be illegal, in order for this to be lewd visual material depicting a child, in order to meet that statutory requirement, it's got to have 1, 2, and 3. It only has 1 and 2. We argue that it does have serious artistic value. And since it doesn't hit number 3, doesn't meet the elements, therefore we are not guilty of this offense. That's going to be their argument. And I think it's a pretty good argument, right? I mean, their argument, they've got this, I watched about 2 minutes of this video from the director of Cuties today that Miss Faith pulled up, and she seems authentic to me. She seems like she really does care about the sexualizing of young girls, and she wants to help. She wants to change the world. She wants to have a conversation about this stuff. I just think she went about it the wrong way, and Miss Faith agrees with that. You know, this was somebody who recognizes this as an issue and tried to do something and speak out about it, but did so in a way that was just, the public just doesn't like it because it feels gross. It feels just wrong. And people can sense that. So, we'll see what happens with this. I don't think that we're going to see Reed Hastings go to prison. Don't think we're going to see the co-CEO go to prison. And I wonder how that's working out for them anyways. I thought the co-CEO thing was not good from The Office. I watched that when, who was it? Michael and Jim, they were both co-CEOs. Didn't work out too well for them. So I wonder how that's working at Netflix. All right, we're going to move on to the big news of the day. Then we're going to go over to the chat. And of course, we're talking about Derek Chauvin. Derek Chauvin, remember this fellow? So this was the man responsible for putting his knee on George Floyd's neck for over 9 minutes, resulting in his death. We see him here. We don't see George Floyd, but this was the infamous photo of him, literally leaning down on him for a very long time until he died. He has been in custody for a long time, and he just got released today on a $1 million bond released on October 7th. He went into custody, I want to say it was June 3rd. If you remember, George Floyd died on May 25th. A few days later, there was a warrant, and Derek Chauvin and the other officers were arrested. Trial date is set. It's coming up. We're going to get there in a minute. But let's take a look at the power of attorney and the bond documents that were signed literally today. And so here's what we've got. So here's what we're talking about specifically. When you're arrested and you're taken into custody and you're held on bond for a high level offense like murder, they're basically what they're doing is they're saying you are too dangerous to be let back out into the public. The charges are too high. The consequences are too severe because you've been charged with murder. If we just let you out of custody, there's a good likelihood you're not coming back. Because if you come back and we convict you, then you're going to go to prison for probably the rest of your life. So if you're faced with that sort of equation, why would you stay around? Why wouldn't you just pick up, move to a non-extraditable country, have a good time, have a good life there, say, everything be damned in the United States? So courts have a lot of concern for that. If you're just regularly, stopped and arrested, say for a DUI case, for example, you're booked into jail. They take your blood, they book you into jail. You sit there for 24 hours, see a judge. Judge will take you into court and then say, well, okay, look, have you been in trouble before? No. Have you ever fled the country before? No. Have you ever failed to show up at a court date? No. All right, well, great. So you're going to be back here in 30 days? Yes, Judge, I promise. Perfect. I'm going to release you on your own recognizance. We're just going to let you out because the judge knows that you're going to come back. If you don't come back, they issue a warrant for you. They suspend your license. They've got other mechanisms to make sure that you show up to court. In a case like in Derek Chauvin's case, because of the severity, there's a strong likelihood this guy's not coming back. So in order to secure his appearance, what they're going to say is you have to give us some sort of collateral. You have to give us something for us to hang on to, then we're going to let you out of custody. So that's what happened here. They said, we'll let you out, but we need $1 million. We need $1 million. And if you give us that, we'll let you out. And that $1 million is going to secure your appearance. So if you don't come into future court dates, then we're going to hold on to that $1 million. And in this case, it sounds like it was a non-cash bond. So essentially what's happening here is he is hiring a bond company. So I'm guessing that he does not have $1 million cash bond. Okay, Derek Chauvin does not have $1 million to just give over to the court to get out of custody. So what he can do, according to Minnesota law, is then go and talk with a bail bond company. The bail bond company can post a certain percentage of that bond. So they don't even have to post the full million. They can post 10% of that, and Derek Chauvin can actually secure that, the remainder of that, with collateral. So he can, mortgage a house or put a house as collateral, or vehicles, or an investment fund, or something else. And so really that's what's happening here. So we have a couple different parties involved. You're going to see Allegheny Casualty Insurance Company. You're going to see another bail bond company. But that's really what's happening, is you're having other parties who are basically speaking on behalf of Derek Chauvin, who are saying, listen, he doesn't have $1 million, but we do. And we're going to post this up, or we're going to work something out where we post 10%, and we're going to have collateral, and we're going to help ensure that he shows up to court. So if he doesn't show up to court, then this is where you see those bail bondsmen, like Dog, the bail bond guy or whatever, the bounty hunter, those types of people. That's where you see them come into play, because now that bail bonds company, they want to get their money back. If Derek Chauvin doesn't show up to court, who's out the money? The bail bonds company is. So they have a very strong incentive to go make sure that they have you, and they can impose their own restrictions on you. So they can make you wear ankle monitoring. They can have you call in every day. They can do things to make sure that they're not going to lose out on their investment. And so what we see here is a power of attorney that was issued, and the defendant is Derek Michael Chauvin. His birth date, it was executed literally today. The bond amount was $1 million. Second-degree murder, third-degree murder, second-degree manslaughter, signed off on by somebody. We don't know who it was. License number. So this is probably the representative from the bail bond company. So the way that it works in Minnesota is you've got these insurance companies and you've got these bail bond companies. And so what they're doing is they're executing a power of attorney to give the bail bonds company certain authority to execute these documents on behalf of Derek Chauvin. And so you've got people signing off on this thing. Not a lot here other than the fact that it's for $1 million. Now, when we move forward, we'll see that this is the actual bond and obligations and conditions release form. So this is where, now that the court is in receipt of the money, now they have $1 million, then Derek Chauvin is now going to be released, signed off on by his attorney, signed off on by the bail bonds company, signed off on by Derek Chauvin himself with his hand-printed name here. We've got Chad, who's the bail bond agent, and they're saying that this is an agreement between Derek Michael Chauvin and Allegheny Casualty, who's the surety signee, who's basically going to pay this amount for the defendant, and they're on the hook for it. So it's an appearance bond, meaning that this is only to secure Derek Chauvin's reappearance in court, and it doesn't have anything to do with his innocence or guilt. It's just to make sure that he shows back up to court. We go back. We have another slide from the court appearance docket. So this is now telling him that the bond has been paid and he's signing for it, saying that he's been advised of his rights and he's coming back to court. He will be back here. They modified this court date. So it was scheduled on 9/11 for some reason, but they put it back to March 8th, 2021 at 9 o'clock in the morning. And so he's been charged with these 5 charges, and he's required to appear in court on the very next court date. But that is not until next year, until March 8th of next year. So we'll see what happens with that. But by and large, he's free. He's out. He's out on his own now. And a lot of people have a lot of problems with that. This case is so hot that I'm concerned about how this is going to go. I'm not real sure that this guy's actually going to get convicted on much. And so this may be just a pressure cooker that will ultimately go off at some point. And we've gone through the statutes in Minnesota. We've gone through a lot here in this case. And this idea that he's going to be, charged or convicted of intentionally murdering somebody, I don't think is going to stick. So we'll see what happens with that. His next court date, as we talked about, is going to be it's going to be a jury trial. So you can see here, this is the final court docket document. Jury trial scheduled on 9 a.m. in front of Judicial Officer Peter Cahill. Now you'll see here that's very far away. There's going to be a lot more activity going on in this case. This is not going to be something that just sits around for 5-6 months until we get to March. There's going to be a lot of activity on this case, but what the trial courts will normally do is they will actually schedule a trial date far in advance because they need to put something down on the books. They need to plant a stake in the ground to say, we've got a trial coming up, and basically you guys got to get your stuff together. Prosecutor, you got to get going. Defense attorney, you got to get going. We're not going to move that trial date. And a big reason they do this is because you have to remember that the defendants have a right to a speedy trial. Remember that as part of our Constitution, your social studies class, right to have a speedy trial. So you don't have to sit in custody for a very long time. You have a right to present your case, because what was happening back before we had this right, they would just charge you and they would just throw you into jail for 2 years, 3 years, 4 years. Remember that movie, The Count of Monte Cristo, when they threw him into the dungeon and he said, "Well, I want my trial," and they said, "Yeah, you'll get it in 25 years, right? When we get around to it." And that's not what we want here. We want speedy due process. Justice delayed is justice denied. And here, there's going to be a lot more activity, but they put that stake in the ground to make sure that everybody is working to that. Now, is that going to happen in March 2021? I highly doubt it. These cases can last years. 2 years would be easy, I think, in a case like this. So we'll see, but both parties are going to be working up towards it. If you recall, these were all 4 of those officers who were responsible for the death of George Floyd. These 4 officers, we had Derek Chauvin, Tao Thao, we had Thomas Lane, we had Alexander Kung. All right. And that's it for the Derek Chauvin case. Wow, we do have, though, literally, as we are live on the air, Miss Faith is doing an excellent job back there, and she just updated my slide deck. So we actually have new information about the Jonathan Price case that I literally have not even seen yet. Let's take a look at this. This is the probable cause affidavit that she just added. What's pretty cool about PowerPoint is you can actually work on the same documents at the same time, and she is doing that. So she was able to find the Jonathan Price probable cause affidavit. We have not seen this yet. I have not seen this yet, but we talked a lot about this case yesterday. So more information is coming out. Looks like the Murder Texas Penal Code 1902 is what that officer, Sean David Lucas, if you recall, we talked about him yesterday. That's what he's being charged with. 6/1/230. Yep, that's his birth date. Sean David Lucas. Talked about him at length yesterday. State of Texas. Before me, the undersigned on this day, Texas peace officer swears as part of the Texas Rangers My name is Laura Simmons. I am a certified Texas peace officer employed by the Department of Safety, Texas Rangers. On Saturday, 10:03, the defendant, whose name, description are shown, committed a criminal offense in the state of Texas. He did commit the offense of murder. There it is. The affiant has probable cause for said belief by a reason of the following facts to wit. This is the meaty part. All right. On Saturday, 10:03 at approximately 8:24 p.m., Wolf City officer Sean Lucas David responded to Quick Check convenience store, located at 103 South Santa Fe Street in response to a reported disturbance. So we had it at about 100 block on Santa Fe Street when we talked about this yesterday. That was the only information we had. The entire interaction is captured on a body-worn camera. Perfect. Officer Lucas was informed by dispatch that there was a possible fight in progress in the aforementioned location. Upon arrival at the convenience store, Officer Lucas was greeted by a male subject, later identified as Jonathan Dwayne Price, 1988. Price came very close to Officer Lucas, asking, "You doing good?" multiple times while extending his hand in a handshake gesture. Price apologized for broken glass on the ground and stated someone had tried to wrap me up. Officer Lucas informed the affiant he believed Price to be intoxicated and attempted to detain Price. Price stated, "I can't be detained." Officer Lucas continued to attempt to detain Price by grabbing Price's arm and using verbal commands, which were both unsuccessful. Officer Lucas produced a taser and informed Price to comply or the taser would be applied. Price failed to comply and began to walk away. Officer Lucas deployed the taser, which was not fully effective. While being tased, Price continued to walk toward Officer Lucas. Price appeared to reach out and grab the end of the Officer Lucas's taser. Officer Lucas discharged his firearm 4 times, striking Price in the upper torso. Price later pronounced deceased at Hunt County Regional Hospital. Ooh, boy. All right. Based on the video evidence, physical evidence, and eyewitness testimony, it's clear that the Officer Lucas did then and there intentionally and knowingly cause the death of Price by discharging a firearm, causing the death of Price. Based on the information listed, reason to believe committed the offense of murder as defined by Texas Penal Code against the peace and dignity of the state of Texas. All right. So that was signed and sworn a couple days ago by the Texas Ranger, Laura Simmons. Wow. All right. We've got another bond amount of $100,000. Sean Lucas David, proved visitors, has a girlfriend, Callie McDonald. And the issuing authority, the S.O. Hunt Co., other agency had him on hold, first-degree felony. So he's been booked into custody is what this looks like. He was placed on administrative leave before. He was only an officer for 6 months before this happened. He was placed on administrative leave currently, and he was only an officer for 6 months before this happened. Yeah, we talked about that yesterday. And so Faye's doing some great research back there. And we talked about this, right? He's 22 years old. Typically, you got to be 21 and a half, something like that in order to get on the force. So they just threw him on the force. He's already shot and killed somebody. Records from the Texas Commission on Law Enforcement show that he served 5 months as a jailer in the Hunt County Sheriff's Office before becoming an officer. So literally breaking news here. You heard it here first, folks, because I just heard it too. Entire interaction between Jonathan Price was captured on body camera, the affidavit says, but the video has not been released yet. Ooh, why is that? Why don't they release these videos? Well, it's probably because it's horrendous. Probably because it's very bad. And if people saw it, then there may be a lot of unrest and a lot of disappointed people. So what you do is you slowly trickle out the information. Don't know why they do that. I think it's a huge mistake. I know why they do it, but I think it's a huge mistake. I think more harm comes from not releasing the information than from releasing the information, because when you don't release the information, all you're giving people the opportunity to do is to speculate, and they will speculate. And that's how we get these stories about the people in Breonna Taylor's case standing over her as she was sleeping in bed, and these people saying that the cops were, just towering over her and just executing this black girl in bed. Well, did that happen? Probably not, but there's no evidence of it, right? We haven't seen anything remotely close to that. But people come up with those conclusions because they don't know any better, because there's no evidence. And so sounds as good as anything else, sounds as good as the cops' version of saying, well, he charged me and all I was doing was defending myself. Well, we have no evidence of that either. So we need to see more material so that the public can actually make a conclusion on these things, because otherwise, if you hide this stuff for months and months on end, people turn into pressure cookers and they start burning cities down. So I understand that the police, they want to hide a lot. They want to, kind of paper over this stuff as best they can. But the public is not tolerating it anymore. People are sick of it. They're tired of waiting 3, 4, 5, 6 months, like we saw in the Ahmaud Arbery case, like we saw in the Breonna Taylor case. They're tired of it. So, my recommendation is for the police to build a public relations response team. They need to get this stuff processed. They need to get it in front of the public quickly. And then we can just address it and move on. All right. So interesting. That was a Jonathan Price update. We'll continue to follow that one along. Also, I think that case is going to be a long, ongoing, probably pretty tragic case. So we'll continue to follow that. Now, before we hop over to the chat, just a little bit of Supreme Court gossip. Not a lot. Just a little tiny bit because it's fun. And Senator Mitch McConnell today, if you remember when his opponent, what was it, Roy Moore, called him Cocaine Mitch? Cocaine Mitch. It's one of my favorite names for any politician, and Donald Trump didn't come up with it. But Cocaine Mitch McConnell, he issued the following statement today, Wednesday morning, following the attacks on Amy Coney Barrett's religious faith. And this is the political garbage that we love to dive into because the Democrats are going to do it. The Republicans are doing it. And we'll just follow this along because we are going to be in the midst of this confirmation debate literally starting next week on the 12th. According to Lindsey Graham, as long as the Senate doesn't come down with COVID, sounds like we are going to just go full steam ahead with the confirmations hearing with the Senate. So this is what Mitch McConnell says. The ongoing attacks by the Democrats on Judge Barrett's faiths are a disgrace. They demean the confirmation process. They disrespect the Constitution, insult millions of Americans. Yesterday, The Guardian claimed that it raises new questions that she chose to go to faith-centered student housing while attending Catholic law school. And he goes on to blast them. Hours later, the Washington Post decided to report on terminology in an old directory from Judge Barrett's religious community. The word handmaid appears dozens of times in the King James Bible. It was good enough for the Virgin Mary, but now, because one liberal author put it in the title of an anti-religious novel in the 1980s, the press tries to imply that one of the most brilliant and powerful women in the legal world is anti-women. Last week, Politico had a contributing editor physically snoop around a faith group in Indiana and report what a youth group had left on their whiteboard. Our coastal elites are so disconnected from their own country that they treat religious Americans like strange animals. All right. So this just keeps going on and on and on. Don't need to read the whole thing, but it is amusing if it just wasn't so sad and just a sorry commentary on the state of our national politics. So Amy Coney Barrett is going to be going through the confirmation hearings. If everything goes as scheduled, it should be next week on the 12th. And then we'll have a final vote. I think the following week thereafter, then we're going to have, several more debates. Then we're going to have the election, and it's just going to be madness. And we want you to be here for it. So hit the subscribe button. All right, let's go over to the chat. So get those keyboards warmed up and let's dive into the chat. So get those questions going. If you're not a regular of the program, good way to get things warmed up is to say, hi, Faith. Just type in there, hi, Faith. She's right behind me. She helps me with this program, and she's amazing. She does a great job, and she actually just literally updated this PowerPoint live. It's pretty cool. All right, so let's go back to some of the questions. If you watch the body camera on Floyd, you'll see an amazing amount of restraint. They never hit him, no chokeholds, did what they were trained to do. The knee on his side of the neck is exact training. All right, well, we'll see. That comes from Eric Twog. Let's see. Jonathan Price resisted detention, fought with the cop, and got what he deserved. Ooh, okay, that's from B. Volkisch. Talking about pressure cookers, the Boston bomber case is applying to go to the Supreme Court. I saw a headline about the Boston bomber, but I haven't looked into that. Yeah, I did see that was going up. We may want to cover that. So we will actually add that to the list. They are going to burn down cities regardless of what the evidence says. Releasing it early will do nothing but taint a potential jury. So you have that as well. You could always move to move your case into a different jurisdiction, which is what happens in almost all of these high-profile cases anyways. So you're seeing that right now. Derek Chauvin, actually all of those attorneys are trying to take their cases out of the Minneapolis area. They want them all to get moved over to a neighboring county where they're going to say that the jury pool is less tainted. Now, in a case like George Floyd, truthfully, I don't know how you get an unbiased jury in the United States. Is there any person in this country that has not heard about this case? Probably, right? There's probably a lot of them. But how do you find those people on a jury? It's not going to be easy. So I think they're going to have a difficult time of getting a fair shake kind of anywhere they go. David Del Pozo says, sup? Sup, brother? Let's see. Lots of high face. Hey, everybody. Media's lied about every publicized death so far. Yeah, I think the media is horrible, which is a huge part of why we do this show. It's, I was seeing all of these analytical takes and opinion and commentary, and I'm thinking, these people have no idea what they're talking about. Have they ever seen a body camera recording before? And so what we're trying to do on this channel is tease out the meatballs from the meat sauce. We want to separate things a little bit. All right, let's see. So how small a crime is worthy of capital punishment without a judge or jury? So capital, I'm not sure I understand the question, but capital punishment is death. So that means you would absolutely get a judge. You would absolutely get a jury. You actually, in many states, you're entitled to mandatory appeal process. So you're getting a lot of due process before you get capital punishment. All right. So somebody else is chiming in on the Price case. He was ODing, panicking. No, that was about George Floyd. ODing, panicking, resisting arrest. Zulu Zeit is back. He says, hey, there are claims that the media is misrepresenting these police incidents. Is there a legal mechanism such as media misrepresentation that makes murdering citizens legal? So I think I'm not a civil lawyer, so I don't do any civil law, not interested in it. I'm almost certain that there are mechanisms that somebody could pursue in order to contest, the media narrative. And it's probably going to be the libel and the defamation laws. It's, for example, you could look at like the Nick Sandmann case where they're saying, something happened and it didn't. They're basically saying that Nicholas Sandmann was somebody who he wasn't, and they're calling him a racist or calling him, whatever they were calling him. He hires counsel. He sues them. He's not a public figure, so they don't need to prove actual malice. They just need to show some malice or intentional malice. And at that point in time, then he is successful on his claims or he settles his claims. But in his situation, he's a person and he's actually suffering damage. So what happens when, let's say, Breonna Taylor or Kyle Rittenhouse or any of those cases, they got to show some sort of damage. And actually, I think Kyle Rittenhouse's attorneys they're actually suing civilly, according to Lynn Wood and some John Pierce and some of those other attorneys that are on his team. They are actually filing a lawsuit because the Biden campaign used a clip of Kyle Rittenhouse and they called him a white supremacist. That was in one of Biden's Twitter posts on, a campaign ad that he did or something like that. And so in that case, you have an individual that has some damages. Rittenhouse is damaged by that claim. In the case of like Breonna Taylor, yeah, she's dead, but her family settled with the city for $12 million. So they're settling those claims. And the media is just sort of not lumped into any of this stuff for some reason. They get away with a lot of it, which is really unfortunate because I think they do stoke a lot of fears. And I've taken flack from both sides on this issue. There are cases where I defend the person who was shot. There's cases where I defend the cops who did the shooting. And, the media, in my opinion, they're just always bubbling these things up. If the world's already at a level 7, they want to turn it to a 10. And oftentimes I think they're sort of writing headlines and fabricating the story in a way that looks good or fits their particular narrative because they only have 30 seconds. You're scrolling on your Facebook feed. They got to get your attention in 30 seconds, which is why I wanted to start this channel because we can do these deep dives for as long as we want. I can spend an hour talking about Kyle Rittenhouse. And I did like 3 or 4 times because I want to go deep and really analyze things and study it and say, okay, now that we've done this analysis, we can reach a conclusion. But the media is just, it's drive-by media. We hear that term. They just drive by, they lob some grenades out the window, fire some bullets, and they're on to the next story. Or they copy and paste stuff. I can't tell you in doing our research for this show how much copy and pasting we see. I go through all the different, so when I do my show prep here, I open up about 25 different websites in the mornings and I look through and I say, what do I want to cover today? And it's amazing at how much they are copying and pasting from each other. So if one person gets a scoop, they will all the other journalists will copy it and they'll all attribute it back to the original author. So if you get one bad domino in there, it's going to trickle out to all of these hundreds of other news sites, and everybody's just copy and pasting journalism. So huge problems with the media. I mean, I think that most of the country agrees at this point, quite frankly. Zach Wallace says, I asked yesterday, but it was hours before the video started. Is there any movement on the Epstein debacle? You know, it's funny that you mentioned that. So we actually started keeping a list of all of the different cases that we're following, and that is one that we have not done an update on in some time. So we know that's going on out of the Southern District of New York, and we were having some problems getting some access to some of those case materials, and I think we got that solved. So we are going to have an update on, in particular, Ghislaine Maxwell. She's got an active case that's going on out of the Southern District of New York. And so that I think is very pertinent, and we're going to have an update on that absolutely next week. All right, R&R Law Group. It's called Mockingbird Media, bro. That's a thing. I've not heard that phrase, but I will take a look. Zulu says, yeah, the media is thriving. It's not dead. So I think that the mainstream, the old sort of traditional media is on its way out. But I absolutely think like online media. So I very rarely watch the actual cable news anymore. I have certain people that host their own shows. They host their own Periscopes. They host their own YouTube shows. And I'm getting more of my news, and I would say more of my analysis from them. So the news people are still responsible for curating a lot of the news and showing us the headlines and showing us what they want us to talk about. But then the people who are really doing, you know, the deep analysis, I can tell you this. I've gotten emails from many of you who watch the show with incredible legal work. I mean, just details from all over the place that are a million times better than anything I've seen ever reported from the AP or from, you know, Fox News or from MSNBC or any of these websites. I mean, the people who are actually, you know, doing the work produce better work more consistently with better analysis. And I think that's where the country is going. I think a lot of people are just sort of getting tired of the 30-second, 60-second, 90-second talking points that you see on the news. And that's really my only point on that. Could the McCloskeys claim that First Amendment protection because they were protesting BLM being allowed to get out of hand and exceeding their rights? Could they claim First Amendment protection because they are protesting BLM? So I don't think that there's any First Amendment implications in the McCloskey case. Nothing that I can see. Nothing I can see there. I think the better argument is that they were on their property. They were using their personal firearms. They were in compliance with the law. There was a real and present threat. There was evidence of actual damage, them breaking through the gates, them entering onto their private property. I don't think it was their private property specifically, but as part of their community property. So they are entitled to some rights about that. And we'll see where it goes. But I think that's the better tack to take. Quite frankly, I'm surprised this case is even being charged. But Eric Twog, the McCloskeys are just a ham sandwich to the prosecutors. They are lawyers. That's the joke. All right. Can't even protect their own property, somebody says, because they're lawyers. What do you do about someone like George Soros who's got these rogue DAs hired? Yeah, that's a good question also. I've seen sort of threads of the George Soros influence, but I haven't taken a very deep dive into those actual connections. To me, it certainly feels like almost conspiratorial. I understand that he's got billions of dollars and he's funding all of these different organizations and these different prosecutors. We talked a lot about this with Kim Gardner specifically. Like, why was she flying over to Europe to talk about prosecution conferences in Europe? What does that have to do with her job as the district attorney? I don't know. But for some reason, she's being flown all over the world for these things. All right. Ed says, thank you. I get upset with you when you turn on police. 99% of them are good, well-meaning people. They should be respected. Yes, there are bad ones, and reform is needed, actually, since prohibition. Yeah, I mean, and I've said that I say that all the time on this show. I support the good officers. I want more good officers, and I want the good officers to call out the bad officers, and I want the bad officers gone. And unfortunately, I think there are too many cultural problems, too many institutional protections that are in place with the police unions and with these contracts that wipe these bad police records clean at the expiration of certain terms. I just think there are a lot of problems, a lot of room for improvement. But the idea that we're going to just defund all police, or this acronym on the internet, ACAB, all cops are bad, is just mind-boggling to me. How are you going to reform your Justice Department, your police department, your sheriff's department, if you just get rid of all of the cops? The idea should be we want to promote the good cops. We want to protect them, incentivize them, give them tools, give them power to call out the bad cops, whistleblower protections, ending the unions, so that the good cops can thrive. I think what's happening right now is that there's this culture of sort of silence, this blue wall of silence, and the cops who speak out, they get smacked down, they get hit on the head, and they get disciplined and reprimanded, or even just ostracized. Even if it's not a formal reprimand, it's just ostracized within their own community because they're not part of that crew. And I'll tell you, I've had conversations with officers. I told the story here on this channel about people in my life who've been stopped by officers who said, they know me, or they work here at the firm, and we do. And the cops will say, "Oh, you work at R&R Law Group? Oh yeah, the Watching the Watchers guys. We love that show. Get rid of the bad cops. We want the good cops. Even the good cops also want the bad cops gone." And that's what the point of this channel is. The point of the channel is not to beat up on cops ad nauseum over and over and over again. But we are watching the watchers, and we do want to make sure that the cops, the politicians, the prosecutors, the judges, the people who we put in charge of ensuring our security and in protecting our justice in our society, we want to make sure that they're held to the same standards that you or I are held to. I don't think there's anything wrong with that. I don't think it's being too mean against the cops. I don't think it's being, too one-sided. We just want to ensure that they're playing by the same rules that you or I are playing in. Because as I've said on this channel, we've been doing this for a long time. I've seen a lot of cops do horrific things, horrendous things, and get slaps on the wrist. Meanwhile, I've seen the same prosecutors from the same county in front of the same judges tell our clients that they don't get that same deal. They get a different deal. Now, they don't ever say it's because, well, he's a cop and your client wasn't a cop. It's for some other nonsense reason, and they stick to their guns on those topics. So we've seen a lot of it, and I think the only way to sort of balance that equation out is by shining some sunlight on the problem, by increasing transparency, by having conversations about it, by encouraging you to be a part of the program, by you to also be a part of the reform movement, by sharing the show and telling your friends, because the only way that we are going to see any actual change is with reform. And I think it's going to happen locally. I think you got to do it in your local hometown with your local senators, your local state representatives, your local city council people. They're the ones responsible for the contracts with the police and for your law enforcement around your city. So that's all that I'm saying. And I understand that people don't like it, that, that this channel incidentally has a lot of negative commentary about these cop situations. And I also have a lot of empathy for these guys. I don't know Sean David Lucas, who's the cop who shot Jonathan Price. I don't know anything about the guy. He's 22, probably woefully undertrained, probably should have never been in that position at all. And he was put in that position. And so that's the problem. And it doesn't justify people going and burning down streets, or, smashing cars, or blocking traffic, or stealing people's beers right off their dinner tables, or, using bullhorns. It doesn't justify any of that. But it is a problem. And we as a society are going to have to deal with it one way or another. So either we don't do anything with the cops, and people still keep getting shot and killed, and people still keep protesting, and the cities keep burning, or we try to address that. We'll say, look, stop burning down the country. We're going to make some sensible reforms. Maybe we can come and meet in the middle somewhere and see some actual progress. All right. I have had cops threaten to tase me in the nuts for no reason. 2 years later, someone got it on camera. He got fired and put in the paper. But I also have family that have been in the police. That's from Mr. K. Mark Carpenter says, do you think the feds will charge Derek Chauvin like they did with Michael Slager, the South Carolina cop who killed Walter Scott, and they got 20 years in a Fed plea deal? I don't think so. I think it's probably going to stay in state court. So I think you're asking, is Derek also going to be charged with the feds? By the way, I think he was charged by the feds for tax evasion. So I think they reviewed his case, and I think they charged him with tax evasion. So he does have simultaneous cases pending. Cops who tase pregnant mothers for going outdoors maskless are not good cops. I know good ones exist, but we have to call it the bad ones. Yeah, I mean, that's exactly what we're doing here, Sarah. That's exactly right. I agree with that. I think that unfortunately, a lot of autonomy has been taken away from cops. You know, they have to do certain things in a certain way for certain people for certain reasons. And unfortunately, that is not always the best approach on every single case. I understand why you have to have procedures. I get it. We have a lot of procedures here at our firm to make sure things are done by the book, and I get all of that. But there are certain situations, like I think that commenter is talking specifically about that Alicia Kitts case, right? Alicia Kitts sitting in the middle of a football game, wide open air, sitting there with her family. Cop says, put on a mask. She says, no. He drags her out of the football stadium. Like, well, he may have been told to do that, but was that the right thing? Did he have any freedom to deny that order or to have a conversation with his superior and say, this is probably not the best approach. Maybe we should rethink this. None of that happens because it's just, we are the authority. You are the subject. You will comply with our command or else. And it's this mentality that the public is just sick of at this point. Systematic issues of lack of training and bad hires versus finger pointing to an individual. Sadly, the latter gives more clicks. Yeah, I agree with that. Yeah, I mean, there is a lot of clickbaity title. Everybody wants to copy and paste their view without doing much analysis at all. And then they move on to the next one. That's why we're doing things a little bit different on this channel, right? We could just do a headlines channel where we just talk about these stories as they break. We could have just, Ahmaud Arbery, that was about a week. Breonna Taylor was about a week. We could have just, really just covered the highlights, but we want to do these deep dives. We want to really dive into these cases and follow them along to see what the outcome looks like. 2 years from now, when Derek Chauvin is either convicted or acquitted at a trial, we want to have been covering the whole thing so that we have a big picture of what really happened. Did the prosecutor really try to prosecute him? Or was this sort of a hand-holding thing where the prosecutor was just sort of, yeah, I got to prosecute him, but doesn't actually put the full force of the law behind him? We want to be able to come to those conclusions. The only way you can do that is through following along. That's exactly what we're going to do. Zulu says we are way past the training excuse. Auditing America says, at R&R Law Group, how can we eliminate qualified immunity? So qualified immunity is something that has been recognized in really two areas. One is either going to be in statutes. So that means that your local state has passed laws that say that there's certain immunity for certain things, and they can do that. So they'll say, in other words, it's codified in law. Now, the other way that you can have it is in case law. That means that judges in your locality, judges throughout the justice system have said that qualified immunity means X, Y, and Z. So an example of this would be in the case that we just went through with Amy Coney Barrett. And she had an opinion that she released out of the Seventh Circuit where they were talking about whether or not an officer who wrote a fraudulent, lying, probable cause statement, whether that officer is protected by qualified immunity. She said because it was a 100% lie, that he's not entitled to qualified immunity. So these decisions are being made on a case-by-case basis. They're analyzing the statute and they're analyzing the case law. They're analyzing the jurisdiction. What state did this happen? What were the facts surrounding this claim of qualified immunity? And so it's something where it's a case-by-case basis. They do a detailed analysis on it. But you could modify it, right? You could say, just by statute, your local state, you could pass a state amendment, you could pass a state proposition, the federal government could do it, the Supreme Court could revisit qualified immunity. There's a ton of different ways that it could go away, but probably the easiest would be a public referendum saying, hey, we want a criminal justice reform here in our state. These are going to be a part of it. No more contracts with the unions, no more qualified immunity, or really going to water down qualified immunity, mandatory Brady list, all sorts of transparency requirements, mandatory body camera requirements. There's a lot of things that we could do. All right. Well, listen, it looks like, oh yeah, the VP debate is coming up. Oh yeah, that's tonight. There's going to be more to talk about. Can you speak to the fact that a lot of people wanting to ignore the reality we live in, where they don't want to listen to the stories or ignore the news? Concerned about this. Thanks. Love the channel. Can you speak about the fact that a lot of people ignore the reality in which we live, where they don't want to listen to the stories or ignore the news? Yeah, that's an interesting question. I can talk a lot about that question. My thought process on this is people certainly listen to things that I think support their worldview. I don't think there's any question about that, right? It's like, why do people only turn into Fox News? Why do people only tune into MSNBC? Why do I follow only a certain number of people on Twitter, whereas where I get my news? I check in with certain people because they validate my opinions, whether I want to acknowledge that or not, right? That's what's happening. I like listening to people who tell me things that reinforce my worldview. I think we all do that just as people. It's just natural. The benefit of recognizing that is that you can watch this media with a little bit of a separate lens. You can say, okay, I understand what they're saying. I understand what they're trying to program my opinion to be, but let me do some of my own independent analysis. Let me think of these things, more analytically. And when you start thinking about a lot of what we're seeing in the world and you put it in context, right? How many people are out there protesting and burning stuff down on a daily basis? On a daily basis, how many of them are out there? Are we talking hundreds of people? Are we talking thousands of people? Are we talking tens of thousands of people? It's not that many people, really. But because the media is so focused on it, and because both sides pick the stories that have an agenda for them, you see, the Breonna Taylor people, they've got an agenda. The Kyle Rittenhouse people, they've got an agenda. And everybody wants to use these stories to really just promote that agenda. And both of them are off, right? Everything is always a little bit skewed. And so as long as you're analyzing these stories with that mindset and you're saying, listen, I'm going to try to present the facts as best I can, but I know that the facts I'm getting, because I don't live in Kenosha, I don't know anything about, that city other than what I've gathered from the other fact finders. So I know it's being filtered and curated before I even get it. Then I filter and curate it, and then I present it. So as long as we're all recognizing that this information is being, slightly altered as it's coming down and we're processing it, I think that's okay. But you have to understand, you have to recognize that. I think the problem comes into play when we're dealing with people who listen to one story. They get on MSNBC and they say, Trump lied about his taxes. And I know that because it's a fact and it's presented on the news. And then they take that fact and they try to run with that. That's where people run into problems, because you have somebody on the other side who's doing the opposite version of that. And you have these two people who don't know anything really about anything other than what they've been told, smashing their heads into each other. And that's not good. I think that's sort of living in a delusion land where you think you're living in reality, but you're really sort of deluding yourself. All right. Railway Hacker says, I am left-leaning, but listen to you in Uncivil Law because you do good analysis, even if I disagree on politics. Yeah, and I appreciate that. I do that too. I listen to a lot of people that I disagree with politically, but I just like how they think. I like how they analyze things. And they ask questions that other people weren't asking, and they spend a little bit more time on the details where some other people weren't spending time on the details. And so I think that's the best thing you can do. As long as you're having an active role in what you're consuming, I think it's more important now than ever to be an active participant. 20 years ago, 30 years ago, you could just sit on the couch and you could put on Walter Mondale and you could just listen to him and you could just say, yeah, that sounds like pretty good news. That's what's going on in the world. But today there's so much technology and there's so much information. Your phone is buzzing at you. Your emails are buzzing at you. Twitter, Facebook, Instagram, everything is blowing you up every which way. So if you just let yourself become this passive consumer of media, you're letting these big entities and these big media companies and these big tech companies and the algorithms just program you into a worldview that they want you to be. And that's what's really dangerous. That's why people get so sick and depressed and just emotional over these things. That's why these people want to kill each other on the streets, because they're essentially being programmed to be angry and resentful at the rest of the world. So if you can be cognizant of that and, just kind of take a little bit of a step back, life's better. I feel better. I'm not so wound up all the time about everything that's going on a day-to-day basis. And it allows me to think more clearly, present more effectively, communicate more concisely. And it's just a better way to live, in my opinion. All right. Well, listen, everybody, I want to thank you so much for being here. It's about that time. and I got to jump on to the next thing. So I want to thank you so much for being here. As a quick reminder, a little show note, we're not going to be here tomorrow or Friday. I've got an in-person conference that I have to go to, which I'm actually really excited about. Going to mask it up and go spend some time with some very amazing people. So I'm going to learn a lot. And unfortunately, that means I won't be here tomorrow or Friday, but we will be back here next week on Monday at 4 p.m. Arizona time, 7 p.m. Eastern time, and we're going to continue to cover everything. I may release some individual videos over the weekend and throughout the remainder of the week, but probably will not be live. So apologize for that, but really appreciate you being here. If you can, share the show, hit the subscribe button. Would love to have you back. We'll be back here next week. Have an awesome rest of your week and an amazing weekend. I'll see you on the